Thank you very much. It gives me great pleasure to join Professor Koopmans in providing an introductory framework for the speech to be given by Justice Ruth Ginsburg. Justice Ginsburg is visiting this country for the 150th anniversary of the 1848 Constitution. And I should like to make a few remarks, if I may, on the significance of the national constitution. Every constitution is a link with the past. How much weight does that past carry now in an increasingly multicultural society, in a society in which the role of government has changed, and in a Europe that is dismantling its frontiers? Is there any future for a separate Dutch constitution within Europe? In a society that's becoming more and more pluralist, the right of recognition possessed by groups and individuals, each with their own backgrounds and identities, is growing in importance. The law will play a crucial role in this mutual recognition. The relevant law is rooted in the Constitution, in the right first formulated in Article 3 of the General Principles of the 1798 Constitution, a constitution that is somewhat glossed over in Dutch history. All members of society, without distinction of birth, property, class, or rank, are equally entitled to the same advantages. Where shared history and a shared background cannot be taken for granted, the fundamental rights enshrined in the Constitution assume greater importance. Can it be a coincidence that the only democracy that does not have a written constitution, the United Kingdom, is an island? Or that the United States, that melting pot of cultures, attaches such great importance to its constitution? The past year witnessed an understandable upsurge of interest in the 1848 Constitution. Like those of 1814 and 1815, the 1848 Constitution's main theme is Dutch polity, or how the state is organized. This organization is important in a country in which, in the words of Paul Kuipers, the state is called the government, citizens are called subjects, and power is referred to with a sense of resignation as authority. But that country has changed. The interdependence of state and citizen, of the state and the private sector, and of state institutions themselves is growing all the time. The legislature, the executive, and the courts rely on one another more than in the past for the effective operation. Hierarchical structures are being superseded in this new constellation by horizontal networks. What does this mean for the three innovations of the 1848 Constitution? That's the involvement of ordinary people in public life, the accountability of persons holding political office, and the primacy of Parliament. Guénon tells us in his La fin de la démocratie that the advent of networks is sounding the death knell for the democratic state. Whether this is true or not, it's clear that the state has little direct control of these networks. Doesn't this mean that we should pay more attention in our Constitution and elsewhere to the quality of public service and less to the organization of the state? The trend towards more horizontal structures in society has consequences for the development of the law, not only at national but also at international level. It's perhaps curious that while this trend has caused some to question the peremptory nature of domestic law, scarcely any doubt exists concerning the peremptory qualities of European law. That European law takes precedence over national law, even national constitutional law, has been determined by the Court of Justice. But can European law also take precedence, for instance, over constitutional provisions regulating matters such as the relationship between government and parliament? Could ministers' obligation to provide parliament with any information it may request, the core of ministerial accountability, be restricted by a European directive? This question is far from theoretical, as became clear during the amendment of the Act on the Supervision of Investment Institutions. In my view, an affirmative answer would be unacceptable, but in the Netherlands it scarcely occurs to anyone even to ask the question. The coming years will witness an increasing demand for a European constitution. What are the common principles of law on which the Union is based in its relationship to the people of Europe, in the way it is structured, in its relations with other legal systems? What should be our contribution to this European constitution? What kind of Europe do we want? A Europe in which the self-interest of the national state ultimately prevails and in which cultural and social identities are sacrificed to the unbending laws of the market? Or a Europe in which national interests are ultimately subordinate to law? A Europe that recognizes the separate identities of the member states? If it is to have strong roots, a European constitution must be the outcome of constitutional development in the member states. In other words, it must develop from the bottom up. For this reason alone, it's essential to remain aware of the principles that are built into our constitution as well as of their historical origins. The national constitutions of the EU member states are embedded in a historical context that is often shared. Last year, we commemorate the Treaty of Münster, and with it, 350 years of the Netherlands as a fully fledged European state. The Peace of Westphalia provided the initial foundations of European legal order, which still makes itself felt today. In 1998, it was 200 years since the Constitution of the Batavian Republic was accepted by referendum, thus regulating the Res Publica in this part of Europe. That constitution included the right of suffrage for foreign nationals. The 1848 Constitution was a direct consequence of European developments and was closely related to the Belgian Constitution, which in turn derived from the Constitution of Louis Philippe's July monarchy. With a past such as this, the answer to the question of does our Constitution have a future in Europe must be a resounding yes. In looking to the future, it's essential that we think back beyond 1848 and that we cherish our Constitution and our whole constitutional past. Thank you very much.
I've been asked by the organizers of this evening to co-introduce Justice Ginsburg's talk by trying to show something of the parallelism between American constitutional experience on the one hand and the current European problems on the other, especially with regard to the role of courts. I've also been asked to do that in about 5 minutes, preferably 4. This is, of course, quite impossible. So what I shall do instead is to try to tell you why this theme is an interesting theme. And I have 3 arguments to show this. That leaves about 1 minute for each argument. Well, approximately. The first argument is the importance of the case law of the United States Supreme Court in constitutional matters for anyone working in the field of constitutional law. That case law embodies, in a way, a real treasure of constitutional concepts, framed by the court and gradually elaborated over the years. To give an example, the freedom of speech, protected by the American Constitution in the First Amendment, gave rise to new and more precise concepts, sub-concepts in a way, such as symbolic speech, when you burn the American flag in protest against the Vietnam War, for example, facing a hostile audience, the preferred position of freedom of speech, that kind of thing, public speech as opposed to private speech, and so on. So together they have the effect of presenting the constitutional problem to be solved in a very pure and unadulterated form. That's one very important argument. The second argument is the contribution made by the United States Supreme Court to the integration of the United States, to the process of forging a nation, especially in the early 19th century. That reminds us of the contribution the Court of Justice of the European Communities made in Europe to the European integration process in the early years of the community's existence, the 1960s and the 1970s. The Court of Justice helped to develop the notion of European law, and in doing so, it reminded politicians of the far-reaching commitments they had assumed and laid down in treaty texts. The court thereby stressed the constitutional value of these texts, even in periods when the political fashion was to forget or to disregard the treaty obligations. The third and last argument is the way European legal developments could benefit from the American experience with regard to equal protection. The United States Supreme Court built up an impressive body of case law concerning the implication of the constitutional equality principles. Here also, new concepts were coined and gradually developed: hidden and indirect discrimination, affirmative action, and so on. This may be very important for the European evolution. First, in the field of fundamental rights, because we discovered in Europe that race problems, which sparked off the new turn of American case law in the 1950s, are not limited to the United States. Britain, France, Germany, the Netherlands, they all have their share of these problems nowadays. And secondly, the European Union is based on the idea of an economic union. And an economic union is characterized by the rule of equal treatment, equality of citizens and nationals of other member states, equal treatment of imported products and homemade products, equal pay for male and female workers, and so on. In developing these rules, the Court of Justice discovered how American case law helped to settle some of the issues. I have no doubt that Justice Ginsburg's talk will be most interesting on its own merits, but it may be even more interesting when the audience keeps some of the European parallels at the back of its mind. Thank you.
It's a pleasure to be with you this evening and to have had two such fine introductions to my remarks. I hope there will be time for conversation with all of you when I'm done. To begin tonight, I would like to tell you a comment that the Chief Justice of the United States recently made on a subject important to judges around the world, judicial independence. The framers of the United States Constitution came up with two quite original ideas, Chief Justice Rehnquist said. The first idea was a chief executive who is not responsible to the legislature, as chief executives are under the parliamentary system. That idea, the Chief Justice said, has not been widely copied by other nations. But the second idea, the idea of an independent judiciary with the authority to declare laws passed by the Congress unconstitutional, that idea has caught on abroad, particularly since the end of World War II. The Chief Justice said of that second idea, constitutional review by independent tribunals of justice is a crown jewel of our system of government. That comment, I think, suitably frames my talk this evening, which centers on judicial review of laws and executive actions for constitutionality, mainly in the United States, but with several comparative side glances. May I remind you at the outset of two key features about the United States system. First, unlike the single set of national courts and unitary law codes that are common in most countries, the United States has over 50 legal and judicial systems, each with its own civil and criminal law, each with its own court hierarchy. Puerto Rico, the District of Columbia, and each state has its own 2- or 3-tier court structure and its own substantive laws governing such basic matters as contracts, property, education, family law, much environmental and health law, and most crimes. On top of those diverse state systems, there are, for the entire nation, many federal laws, both civil and criminal, incessantly enacted by Congress, and one federal court system with trial courts of first instance, dispersed throughout the territory of the United States, and 13 courts of appeals in different regions of the country, only 2 of them, the Federal Circuit and the D.C. Circuit, on which I served for some 13 years, specialized to any degree. The rest are all generalists. And on top of that, one Supreme Court. Our state court systems vary in a number of ways. For example, many of them have elected judges, a means of selecting jurists that is astonishing to most civil law jurists. And many others have, as the federal system does, appointed judges. All federal judges, first and second and final instance, are appointed by the President, confirmed by the Senate, and we enjoy life tenure with no compulsory retirement age. As a second basic feature, I stress that most of the work of the United States Supreme Court, unlike the specialized constitutional courts that have been created in Europe following World War II, most of our business has nothing to do with the Constitution. Rather, it involves the interpretation of sometimes very dense statutes passed by Congress. Judicial review for constitutionality is the most closely watched part of our business, but it is far from the largest part. Our heavy load of cases that do not involve the Constitution's grand clauses explain in considerable measure why 5-4 decisions are returned in less than 20% of the cases we hear. In over 40% of the argued cases, the court currently reaches a unanimous judgment, and that is a reality little noted by the U.S. press. The first appeal in the United States, in both state and federal systems, is generally a matter of right. You are entitled to a second hearing. But that appeal is always on the law, never on the facts. We hear no witnesses. We see no new documents at the appellate level. The Supreme Court, unlike the lower appellate courts, chooses almost all the cases it will consider, and the court is highly selective. Nowadays, the court receives about 7,000 petitions for review in a year, and of those thousands, the court annually selects not more than 100 to hear and decide. We adhere to a rule of 4. If 4 of the 9 justices vote to take up a case, review will be granted, and if 4 do not, review will be denied, generally without comment. A denial of review by the Supreme Court neither approves nor disapproves the lower court's judgment. It simply leaves that judgment undisturbed. Our court does not sit to correct mistakes that other courts have made. We have a good 2-tier system that takes care of most of what we call error correction. Instead, we limit our docket to the most turbulent federal statutory and constitutional controversies, and about 70% of the 80 to 100 cases we agree to review in a court year present what we call deep splits. That means strong disagreements among federal courts, sometimes state courts, sometimes both, over the meaning of a federal statute or a federal regulation or a constitutional provision. In January 1999, for example, just last month, our court heard argument on a question whether under a provision of our nation's anti-discrimination laws, students may sue school districts for the school district's failure to prevent or to remedy student-on-student sexual harassment, or similarly racial harassment. 5 courts of appeals had considered and decided that question. 3 answered yes, the school district is responsible, and 2 ruled no, the district is not. In the fullness of time, before we leave town in June, that case will be decided. During the October 1998 term, we resolved a conflict among 9 courts of appeals. The Supreme Court held in that case that a person who just says no without elaboration when asked by the police if he engaged in criminal activity has no license to tell even that unadorned lie. For a not true no, the hapless fellow is vulnerable to prosecution under a statute banning false statements to federal officials. I wrote separately in that case. I questioned whether Congress really meant to arm the police with so easy a means of snaring a suspect. We sometimes grant review because the question is so urgent, there is a need for an immediate national answer, and we don't have the luxury of waiting for a split. One such case was the constitutionality of term limits for members of the national legislature, an attempt by states to put a limit on the number of terms representatives could sit in Congress or senators in the Senate. Another case that we took up sooner rather than later involved whether the states could prohibit physician-assisted suicide, and most recently we heard one involving permissible techniques for conducting the 10-year census of the population. Our judges in the United States, our federal judges, unlike judges in many civil law countries, are not part of a career bureaucracy. We have no training for judicial careers. Judges do not enter the judicial career and go up the ladder in it. Judges are appointed to the federal courts generally after long and distinguished careers in diverse fields of legal endeavor. They are generally appointed at ages closer to 50 than 40. And that is true of judges at all levels, first and second instance judges, as well as Supreme Court justices. Federal judges, prior to their appointment, may have been practicing lawyers, they may have been law teachers, government officials, even members of Congress, or judges of state courts. I should add that some of the finest jurists in the United States never gained appointment to the Supreme Court. In the 20th century, Learned Hand is a particularly notable example. More than a little bit of luck determines the particular 9 who sit on the U.S. Supreme Court at any particular time. A highly regarded jurist, Robert H. Jackson, who served on the Supreme Court from 1941 until his death in 1954, with an interruption to be the chief prosecutor at Nuremberg. He explained that the Supreme Court, the justices of the Supreme Court, are not final because they are infallible. Rather, they are infallible only because they are final, because the system gives them the last word. Federally appointed judges, I take great pleasure in repeating, are appointed for life, or in the words of Article 3 of our Constitution, during good behavior. And justices not uncommonly sit well beyond their 75th birthday. Justice Holmes, for example, stepped down at age 90, and in more recent times, Justice Brennan retired at age 84, Justice Blackmun at age 85. The twin safeguards of life tenure and no diminution of our pay while we are in office, those two safeguards are the U.S. Constitution's prime promoters of judicial independence. Professional judges in civil law countries, I think it fair to say, judges who train for a judicial career from early days, are well-respected officials, and they enjoy the esprit of a career judiciary. But they have little room for the stylistic individuality that U.S. judges have, and they have not been accorded, at least formally, the law development function customarily exercised by life-tenured judges in the United States. Federal courts in the United States, as I already indicated, are generalist courts. Their members do not sit, as many continental judges do, in sections divided by subject matter, nor is any judge assigned to be the reporting judge on a matter or a proceeding. Each of us independently prepares first for the hearing and then for the conference on a case. And in marked contrast to the European Court of Justice, for example, and I believe the Netherlands High Court, we have no officer akin to the Advocate General, no officer to furnish us with advice in the form of an elaborate opinion. We do receive friend of the court briefs from groups interested in letting us know their views. In the so-called right to die cases heard in 1997, for example, we received 70 briefs from various friends, groups that ranged from medical organizations, nurses organizations, hospice workers, and associations representing disabled people. A match for our all-purpose judiciary, we also have an all-purpose bar. The barrister-solicitor distinction, not yet abandoned in England, never took hold in the United States, nor have we ever had anything akin to the French notaire, avoué, avocat division of labor. Let me turn now to the way in which courts in the United States control both legislative and executive action for constitutionality. That competence, as I said, is not lodged in one special tribunal. Every court in the United States that exercises general jurisdiction, state courts as well as federal courts, applies the Constitution as the supreme law of the land. Because constitutional review, United States style, is dispersed, the system has been called decentralized to distinguish it from European systems in which only one court is empowered to review legislation or executive action for constitutionality. For example, the Constitutional Court of Germany, or of Italy, or of Spain. No federal court in the United States can preview a law before it is promulgated the way the Constitutional Court, the Conseil Constitutionnel, does in France under that nation's 1958 Constitution. It is true that some state systems, Massachusetts most notably, do have an advisory function. The highest state court in Massachusetts will respond to questions asked by the legislature on the consistency of a proposed law with the state's constitution, and that highest state court will render the advice. And some states permit federal courts to certify to the state's highest court a question of state law that may be determinative in a federal case. That kind of certification, reference of a question to a court that is competent to rule on it, somewhat resembles the European Court of Justice's reference jurisdiction. A proposal had been made at the U.S. Constitutional Convention way back in 1789 to establish what was called a Council of Revision, a body that is similar, that would have been similar to the current-day French Conseil Constitutionnel. Judges would be appointed to that council, and they would join with executive officers, also on the council, to pass on a law's validity before promulgation. But the founding fathers of the United States rejected the idea of such a mixed tribunal. Federal judges, the United States Constitution has been read to say, may hear only fully ripe, live cases or controversies, and they may not give advisory opinions. The U.S. bar on advisory opinions has not been copied by our neighbor to the north. Canada's Supreme Court entertains hypothetical or anticipatory questions referred by the federal government. Just last February, a year ago, on the petition of the government, that court took up the difficult issue, does the province of Quebec have authority under national or international law to secede from the federal union. The Canadian justices ruled that a simple vote in Quebec would not allow secession, but that if a clear majority of the province's residents voted for separation, then the rest of the nation would be obliged to negotiate some means of accommodating that strong sentiment. An opinion of that order could not be provided by federal courts in the United States, for they are empowered to adjudicate only full, ripe, actual cases. They may not respond to questions separated or abstracted from a particular case any more than they may preview legislation. Instead, as I hope I have made clear, the federal courts must deal with live, whole cases, William Marbury's, Fred Korematsu's, Frey Lepoule Griffiths, or Nancy Beth Cruzan's case. And the cases must travel the full course. They must go from the federal court of first instance or state court of first instance up the ladder to an appellate tribunal, and each court in its turn will express its judgment on all issues, including the constitutional issue. Each court will opine on every issue needed to wrap up the entire case. A trial court judge, U.S. District Judge John Sirica, was the first one to rule on the question ultimately decided by the Supreme Court in the Watergate burglary case. Although our system is decentralized and case-specific, it is not chaotic. It does not produce Tower of Babel results, thanks in good part to the rule of stare decisis, or following precedent, that instructs courts to follow prior decisions, and not just what the French call jurisprudence constante, that is not a series of decisions. Any decision will gain force beyond the particular case and the parties through the doctrine of stare decisis. Each court respects its own prior decisions. Intermediate courts of appeals decisions bind all the lower courts in their region, and U.S. Supreme Court decisions set precedent for all courts, federal and state, in cases arising under the Constitution or laws of the United States. Constitutional review by courts in the human rights sphere is perhaps the most vibrant judicial power issue, not only in the United States but elsewhere, as we rapidly approach a new century. In the human rights domain, may I highlight some significant differences in premises and approaches in the United States and in other nations. Review for constitutionality in the human rights area became prominent in my country and elsewhere after World War II. It is true in the United States. It is also true elsewhere because World War II and the totalitarian rule that preceded it unsettled the belief of many that one could securely rely on popularly elected legislatures to protect human rights through law. For much that was evil had the stamp of approval by elected legislators in that time. So post-World War II constitutions in several European nations provided for constitutional review, although generally in specialized courts set apart from the regular court hierarchy. They set up those courts as bulwarks against autocratic government and a safeguard of individual rights. Many jurists in the United States regard constitutional review by courts in the human rights sphere as our nation's hallmark and pride. I agree, but with the caveat that the pride should not be overweening, because judges are fallible and have made some dreadful mistakes. My dreadful mistake list would be a very long one, but let me mention perhaps the most infamous, the Supreme Court's 1857 Dred Scott decision, in which the United States Supreme Court used the majestic due process clause of our Constitution to justify one individual's right to hold another in bondage. I appreciate, too, that in its Declaration of Human Rights, the United States Constitution is not regarded as a model document for a modern state. The United States is not old among the world's nations, but its Constitution is the oldest written Constitution still in use. It was drafted in 1787. A terse Bill of Rights was added 4 years later, and thereafter it has been amended only 17 times. Most of the world's nations have constitutions written since 1970. As composed in 1787, the United States Constitution dominantly concerns the structure contained no equal protection of the laws guarantee. That didn't enter the Constitution until 1868, after a civil war ended slavery. And the Bill of Rights, our Bill of Rights, for the most part, does not even declare our most basic rights. Instead, it assumes they exist and simply tells the state to keep its hands off them. Our principal rights-declaring document, indeed, is not the 1787 Constitution or the 1791 Bill of Rights. It is the 1776 Declaration of Independence, a document that is not directly enforceable in court. The Declaration, in ringing tones, declares, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." According to this text, human rights predate the state. They are not the state's to confer on its citizens. Rather, the state is to be kept from trampling on them. So the First Amendment to the United States Constitution does not say, as the French Declaration of the Rights of Man does, it does not say every citizen may speak, write, and publish freely. Rather, our First Amendment simply assumes that that right exists for all humans, and not only citizens, and so it says, Congress shall make no law abridging the freedom of speech or of the press. Modern human rights declarations in national and international documents do not follow the U.S. Bill of Rights' spare government hands-off style. Not only do contemporary declarations contain affirmative statements of civil and political rights, but they also contain economic and social guarantees. For example, the right to obtain employment, to receive health care, a free public education, and even more grandly, the state's assurance of the conditions necessary to the development of the individual and the family. The United States today surely is not blind to the importance of economic and social security. Indeed, well over half a century ago, President Franklin Delano Roosevelt stated in his January 11, 1944 State of the Union message that the nation had come to accept a second Bill of Rights as self-evident. Necessitous men are not free men, Roosevelt said. While a world war was still raging, the president listed goals for a lasting peace, his aspirations for all people, regardless of station, race, or creed. The right to a good education, to earn a living, to secure decent housing, adequate medical care, protection from the economic fears of old age, sickness, accident, unemployment. We cannot be content, President Roosevelt told the nation, if some fraction of our people, whether it be 1/3, 1/5, 1/10, is ill-fed, ill-clothed, ill-housed, and insecure. Yet FDR and all who shared his hopes for the future understood that we must rely on legislation to declare and implement safety net protections. Implementation of economic and social security is also accomplished by detailed statute elsewhere. So the explicit constitutional status of economic and social safeguards lacking in the United States does not have, in my view, telling practical effect. One reason for the resistance in the United States to placing economic and social guarantees right in our Constitution is our view that the Constitution is law to be enforced here and now. It is not aspirational to be achieved over time. Another is our style of constitutional review. Our courts, through judicial review, are accustomed to telling government what government may not do. Our courts are not, by tradition or staffing, well equipped to map out programs about what government must do. Now, of course, a decision that says the state shall not often indicates what the state shall do. In a 1996 case, for example, the Supreme Court said that the state of Virginia could not maintain a military college, the Virginia Military Institute, for men only. Well, that meant that if the state continued to maintain that college as a public institution, the school would be obliged to admit qualified women. Observers of judicial activity in the United States might raise a question at this point and might ask, is it not true that in the USA, occasionally courts map out precisely what the administration must do, or what about the decrees involving desegregation of schools, reform of prisons and mental institutions to establish minimum health and safety requirements, or drawing the boundaries of electoral districts? Litigation of that kind was needed, and accordingly it was developed in the United States in the 1960s and 1970s for one glaring reason: it was needed to end racial apartheid in the United States. It is the kind of business courts will undertake when pressed by litigants only in the last resort, only when the political branches, the legislature, and the executive have failed to carry out their constitutional responsibilities despite repeated notice and ample opportunity to address the problem. Although judicial review for constitutionality has very deep roots in the United States, it remains a sometimes fragile or perilous characteristic of our system. Henry Fielding wrote in Joseph Andrews that examples work more forcibly on the mind than precepts. So let me supply a concrete illustration, first of the primacy of court review for constitutionality. My chief case in point is one to which I already alluded, a 1974 unanimous opinion written by Chief Justice Rehnquist's predecessor, Warren E. Burger. The opinion is titled United States v. Nixon. On Chief Justice Burger's death, a New York Times obituary called the opinion the pinnacle of Burger's career and one of the U.S. judiciary's finest achievements. The case concerned a subpoena issued by U.S. District Judge John Sirica, directing the President of the United States to produce, for use in an ongoing criminal proceeding, tape recordings and documents capturing Oval Office conversations between Nixon and his advisors. In his campaign for the presidency, Nixon had repeatedly called for the restoration of law and order. He pledged that he would appoint judges equal to the task, people who would not be soft on crime. A U.S. Supreme Court that included 4 Nixon appointees, in addition to Chief Justice Burger, now Chief Justice Rehnquist, and Justices Powell and Blackmun, that court declared the law and affirmed Judge Sirica's order, which the President obeyed and then promptly resigned from office. Another more recent example, one attracting much hindsight commentary from many mouths and pens, very strong criticism of my court's opinion. In Clinton v. Jones, a unanimous Supreme Court in May 1997 rejected arguments made on behalf of the President who appointed Justice Breyer and me. The court held that the Constitution itself did not grant the President special immunity, even temporary immunity, from a personal injury suit based on an episode allegedly occurring before he took office. Congress, of course, could have provided for such immunity by law, but it had not done so. The court stressed in its opinion that it was a who decide question, the legislature or the courts, and it also stressed the large discretion entrusted to the district judge, the court of first instance, to control the course of the lawsuit by granting appropriate postponements or limiting the areas of inquiry. Well, time and again, and we are now in such a time, some members of the U.S. Congress and of the press write or act as if they do not understand how seriously most federal judges take their obligation to construe and develop the law reasonably and sensibly, with due restraint and fidelity to precedent, and to administer justice impartially. I turn back to conclude these remarks to the issue of judicial independence, for only a judiciary independent of the political branches can act as a check on the extra-constitutional excesses of government. I will use a personal example to show the perils jurists engaged in constitutional review often encounter. In the fall of 1996, I gave a talk at Louisiana State University in which I endeavored to explain, as I did tonight, the difference between the late 18th century Constitution and Bill of Rights of the United States and more modern human rights documents dating from the December 1948 UN Universal Declaration of Human Rights. An Associated Press stringer was present at the talk. He did not follow my words assiduously, and he misreported what I tried to convey. The AP report said that I called the U.S. Constitution outdated, skimpy in comparison to the UN covenants, in need of fleshing out. In fact, I praised our Constitution as it has evolved over the course of U.S. history. The AP printed a correction But bad news, however incorrectly spun or distorted, is not easily erased. A sampling of the letters received in chambers from readers of the incorrect release. Your extreme views are outrageous. I am calling for your resignation. I deplore your alien anti-American ideology. I am ashamed that you were ever appointed to your position, and especially ashamed that you are a woman. In April 1997, the American Legion magazine, a journal for armed service veterans, reported in its Washington Watch column, American Civil Liberties Union views dominated Ginsburg's speech at Louisiana State University. She's showing her true colors, a spokesman for the Judicial Selection Monitoring Project commented. Ominously, the Legion magazine added, congressional insiders predict the fallout from Ginsburg's talk will be intense Senate scrutiny of President Clinton's future nominees to the federal bench. I am in good company in this vulnerability. At a January 1998 meeting of the American Bar Association litigation section in Hawaii, Australia High Court Justice Michael Kirby gave a talk in which he commented on judge bashing as a worldwide phenomenon. Justice Kirby mentioned the 1996 remark of the UK's current Lord Chancellor condemning judicial invasion of the legislature's turf. Judges in New Zealand, Kirby noted, had been castigated for bail decisions that went awry, and a former Prime Minister of Australia accused his country's High Court of undermining democracy. Australia's Deputy Prime Minister promised in 1997 that when High Court justices now sitting on the court reached the mandatory retirement age of 70, the government would appoint in their stead capital C conservatives. The conservation work needed in the United States, as I see it, is of a different kind. It is to conserve the historic role of courts under our constitutional system, in Hugo Black's words, the authority and the responsibility of the third branch, to stand against any winds that blow, to stand as havens of refuge for those who might otherwise suffer because they are helpless, weak, outnumbered, or because they are non-conforming victims of prejudice and public excitement. The United States judiciary, for all its shortfalls, has been a model in this regard. It is true that our independence is not always easy to convey to colleagues from abroad. In the fall of 1997, for example, after 2 full days of heady intellectual exchanges between members of the U.S. Supreme Court and Russia's Constitutional Court on the prime place of judicial independence, the Russians thought they grasped the reason for our security. They were particularly eager to speak to the U.S. Marshal Service officers who were attending and protecting us. Their protectors worked for the executive. Ours, they sensed, took care of and owed fidelity solely to the judiciary. I confess that in my views on the prime place of independence for federal judges, I am what legal academics in the United States call an originalist. I am mindful of one of the grievances against England's King George III, enumerated in our Declaration of Independence. The founders declared, he has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. In this light, may I recall the words of James Madison, the words he spoke when he introduced into Congress the amendments that became our Bill of Rights. Independent tribunals of justice will consider themselves in a peculiar manner the guardian of these rights. They will be an impenetrable bulwark against every assumption of power in the legislature or executive. They will be naturally led to resist every encroachment upon rights expressly stipulated for in the Constitution by the Declaration of Rights. May that account become more real than visionary of courts of justice in all lands. Thank you for your patience.
Thank you, Madam Justice, for your fascinating helicopter ride over this imposing institution you've been a member of since 1903. And if I may recall for the audience, you've come from quite a distance. Daughter of immigrants, working your way through schools, an outstanding student career at the law schools of Harvard and Columbia University. And then you found yourself too much a Jewish woman, a Jewish lawyer, and a Jewish mother. 3 bridges too far to be hired by the legal profession in New York City. Yet, the adjacent state of New Jersey was wise enough, at least Rutger's University, to hire you. And later on you became an important member of the staff of Columbia Law School to become a federal court judge. And then in 93, the current President of the United States was wise enough to propose you and let you become the second woman Supreme Court Justice. Can you, for the audience, recall what surprised you most after this already impressive career when you had finally made it to the Hill and when you became one of the 9 pillars of legal wisdom in the United States?
The biggest and most pleasant surprise is, contrary to the brethren and a more recent book, the U.S. Supreme Court is the most collegial place I have ever worked. The 9 of us genuinely like each other. We are constantly in each other's company. We choose to have lunch together every day we sit. We genuinely care about each other's families. We celebrate such events as my granddaughter's 3rd birthday at the court. So beyond any law faculty, beyond the Court of Appeals where I worked, this is a truly collegial institution, and all of us appreciate that institution is so much greater than the 9 of us as individuals.
So all this talk of political nominations is actually for the papers?
Of course, political views enter into a judge's selection by a president. One can think of no clearer example than President Eisenhower, who chose Earl Warren, a tough-on-crime prosecutor, governor of the state of California, supportive of evacuating the Japanese Americans, appointed Earl Warren to be Chief Justice of the United States Supreme Court. And yet history will recall Earl Warren as one of the bravest, boldest, liberal Chief Justices we ever had.
You've been talking about presidents taking the courage to name people they didn't want to hire and yet got. And you just mentioned Madison's fascinating compliment to the Supreme Court, talking about an impenetrable bulwark against every assumption of power. Why actually did the American people put more faith in its partly non-elected judges than in its elected politicians? Might it stem from a distrust of democracy? Or what is it?
I'm not sure they knew exactly what they were doing in those days. Do you know that the Supreme Court originally was not considered a very important place to be? One justice, Rutger, early on, resigned to become the chief judge of the state of South Carolina because he thought that that was more important, the state judiciary. Marshall had to be he was third or fourth, depending on whether you count Rutledge. He was not altogether sure that he wanted the job, but he took it, and he made that court the institution that it is. He saw the need to take 13 jealous colonies and forge them into one nation. And the people liked it. Commerce was better, as I think the EU is finding when there are not trade barriers. So the Constitution itself is kind of vague on whether the courts have this judicial review authority, but Marshall exercised it, and it worked.
If the Supreme Court has managed to become this most trustworthy authority for maintaining what you call the law in the United States, more so than the democratically elected Congress, why is this Supreme Court, in the very instance we're living at the moment, not good enough when it comes to judging the highest executive authority in the land? I mean, legislators considering hiring judicial gowns proves the point that there is a question mark.
Because on that question, the Constitution leaves no doubt. It says that the president will be impeached by the House and tried by the Senate. It gives no role to the court. It gives a role only to one person, and that's my boss. He is to preside. The Constitution says he will preside when the president has been impeached. But otherwise, the Constitution says for this special case, for the impeachment of the president for high crimes and misdemeanors, the prosecutor is the House of Representatives, and the judge and jury of the Senate, and they have the last word.
Yet you just gave two, in my ears, fine examples of the Supreme Court being very delicate and effective in dealing with president's matters.
But the Supreme Court did indeed say that it is out of the business of impeachment, that the Constitution gives that business. So we did consider the question and ruled on it. Not in the current case, but in another instance.
Is it an ideal setup?
What?
The current one?
It's only the second time in the history of the United States. It's a long time it's 130 years since Congress exercised that kind of muscle over the executive. You know that the Chief Justice, who is currently presiding over this trial, wrote a book called Grand Inquest. He thought that it would be and never or hardly ever again after those 2 episodes. Whether he's right remains to be seen.
So next century we'll take it from here.
Yeah.
Can you tell us in practical terms how the Supreme Court stays clear of political pressures? You just mentioned a few examples of famous Supreme Court justices who stayed on till they were over 85. I sort of recall that some of them were aware of the political balance and that helped them stay on for a while. What's the reality of political pressure within the court?
I doubt that it affects a person's judgment when to leave. For example, Justice Brennan was urged by some of his friends to retire earlier so that his successor could be appointed by a Democratic president. He thought that he was doing a good job on the court and he didn't want to leave it until his doctor told him it was time to go, and that's what he did. And it happened to be on a Republican president's watch. So I think people stay in this job as long as they think they can do it effectively.
Well, if I may take your personal example, you've been known in the United States for quite a while as an advocate of women's rights, of human rights. You were a liberal. Has it been an advantage or a handicap that you were a women's rights advocate?
Overall, a tremendous advantage. I had the great good fortune to be born at the right place and the right time. I contrast what my mother's chances were, what her mother's chances were. There had been no time in the history of the United States when a woman could aspire and achieve to do whatever her talents would enable her to do. Until now, there were so many closed doors. Well, you don't want me to talk long, but I will tell you one story. The United States still has juries. We use them in civil cases and criminal cases because the Constitution requires it. But in many states, including my home state, women were not put on juries. In my lifetime, one of the big set of cases that I advocated was to put women on juries as the same basis as men. The very last case I argued in the Supreme Court was on that subject in 1979. That was rather late. On the brief, the turning point brief in the sex discrimination area, I put the names of 2 women, one Pauli Murray, the other Dorothy Kenyon, who had fought all their lives to give women an equal chance, and particularly to put them on juries. They were too old to participate with me, but I knew I was standing on the shoulders of those great ladies. In the 70s, the country was ready. In the 50s, it wasn't.
Thanks mainly to your wonderfully effective and, as some people say, wisely moderate advocacy for women's rights. And these days one reads that you're for judiciary modesty. Do you think that you won a number of battles the Supreme Court should not have conceded in making the law?
I'm not sure that I understand the question.
You've been rather effective as an advocate
Yes.
of women's rights.
Yes?
The Supreme Court, under your wise hands, has explained the law in a favorable way for women's rights, contrary to tradition, as you've experienced
Yes.
yourself. These days, I read about your work that you favor a modest judiciary that's not writing the law all the time, not telling the executive how
Yes.
to legislate.
Yes.
Do you think you've seduced the Supreme Court to be more activist than you would like to be yourself?
I think in the cases where I was an advocate, the Supreme Court was just putting its stamp of approval on the side of a change that had already occurred in society. Some states move slower than others, but on the jury, it was never just go to the court alone. It was, you tried to get the states to change their laws, you tried to get the federal government to change its laws. All these things were working together. To take just one of many examples, in the 1970s, the military, our military academies, West Point, Annapolis, they did not admit women. A lawsuit was started with very able plaintiffs. Congress, in the middle of the lawsuit, decided, gee, they're right. We should open the doors of the academy to women. So I'd say that our institutions are interdependent in that way, and there's always a dialogue going on between the courts and the legislative branch. But I cannot, obviously, as a member of a body of 9, just project my will and rule all the others. I have an expression I use sometimes. If I were queen, there would be this or that. But I'm not. I'm there with 8 others. And I much rather carry, at least 4 other minds to make 5, and write small than write a grand dissent for 1.
If you were the Queen, I'm pretty sure you would change the law concerning the death penalty in the United States. As you arrived in Amsterdam, you still had to give your opinion on a case concerning life and death. Is it at odds with human rights, as you've always advocated?
I can just tell you that this Constitution of ours twice refers to capital crimes, so it assumes that there is a death penalty. That's one hurdle to overcome. Another is to be part of a system where the people have strongly said they favor the death penalty. I think in our earlier conversation I told you about California, where the Supreme Court of California said the death penalty is cruel and unusual under all circumstances and therefore is invalid. The good people of California put that issue on the ballot, and they voted overwhelmingly to amend their constitution to reinstate the death penalty. Well, that's just an example of the court, the people. How far in front of the people can a court be if it expects its judgments to prevail? Now, my spouse will confirm that the first time I was in this business, I was a judge for 13 years in a place that had no death penalty. The D.C. then had no death penalty. When I got to my new court, I found first the law was impossible. It was very, very dense. Nancy will back me up on that. It just to learn it. And the first night, the execution was at 3 a.m. I stayed up. I cried, and it was over. And I have to make a decision. Am I going to be part of this group and try to be an influence, or am I going to say, I will take myself out of it and therefore not be effective at all in the decisions that are made?
And do you every now and then come up with new arguments to try to convince the friends of your grandchildren?
We seldom are original in the Supreme Court. You know, we get these briefs from all sides and all friends. And I think I mentioned to you one recent decision. The defendant said, there's a choice that the jury didn't know about. That is, it wasn't the choice between putting me away for a term of years or killing me. There is in this state a sentence of life in prison with no possibility of parole. And the court said, yes, the jury should have been told that that was an option, because maybe they would not have administered the death penalty if they knew that this very, very dangerous man would never be out on the street again. So those kinds of decisions are made.
So you mainly try to follow the same strategy you've so successfully used in the 70s in an adjacent field.
I think that the two fields are not comparable. In terms of, I said that I was born at the right time. The society was ready to draw on the talent of all of its people and not just some of them. It's not at the same stage now with respect to
Questions
the death
about the death penalty are fairly easy, fairly European. Have you got? I don't mean they're easy in general, but they're easy to put as a European. I mean, have you got points of almost equal surprise or astonishment about European legal theory or practice?
I think it's wonderful. I once attended, Robert Badinter spoke in the United States, and he took great pride about how the death penalty was abolished in France on his watch as Minister of Justice. One could say, and he said the people never would have voted for it. Well, what about a democracy? I mean, what is the people's will? He was successful, and France never chose to go back the other way. But the question is, who decides? Does the executive decide? If the legislature decides, that's fine. Those other people elected to make that kind of judgment. Do the people decide, as they did in California, the other way, to have a death penalty? The death penalty is the question of who decides is a very important one. And in some societies, it's easier for the executive to make that decision than it is in others.
Maybe it's a good moment to see what the people's questions are like.
My name is Tom Zwart. I'm from Utrecht University. You have briefly referred to the book called The Brethren and another behind-the-scenes book, the Lazarus book, about the Supreme Court. Undoubtedly, these behind-the-scenes books, attract an audience which is much wider than the legal community, and they inspire a lot of attention to the Supreme Court. But do you welcome such publicity? And if you don't, which I felt when you made your remark, which are the alternatives to meet the need for information among the people about the Supreme Court?
I think that all of us feel a need to have information, accurate information, conveyed to the public about the Supreme Court. My Chief Justice has now written 3 books. His first one was on the Supreme Court, how it worked then, in the days when he was a law clerk, how it works now, in the days when he's chief. I have written something that's been published in a law review about, that I call the workways of the Supreme Court. There are some very good biographies of individual justices that give you a glimpse of life on the court. I think what mainly turned up in the Brethren was that there was no smoking gun, that there was nothing really to report. The Lazarus book, all I can say is he's writing about a year when I wasn't on the court, but what he says about the relations among my colleagues is certainly nothing that I've experienced. Well, I'll give you just the kind of example of the greetings that I received from my colleagues. Justice White, whose seat I took, sent me a packet, and he said, "Don't open this till you're finished with your confirmation process, but when you do, maybe it will be a little help." It was his manual of chambers procedures that he and his law clerks kept up and improved every year. Well, that gave me a wonderful start to read through the whole thing and understand step by step how the court worked. Justice O'Connor, when I announced my first opinion for the court, the rumor is that the new justice gets a simple, unanimous decision. Well, my case wasn't simple. It was a really dense, sticky pension case. And it wasn't unanimous. It was 6-3. And Justice O'Connor was on the other side. As I read the summary of my opinion from the bench, she passed me a note and said, "Ruth, this is your first opinion for the court. It's a fine opinion. I look forward to dozens more." That kind of spirit that prevails among all of us.
My name is Alton Heringa, and I do not work for Associated Press, so I hope my question reflects your very stimulating speech. I want to ask you a question about the beginning of your talk, namely how the Supreme Court chooses out of the 7,000 petitions the 100 cases to be decided. You said that not a criterion is basically whether an error has been committed by an inferior court.
Right.
Could you elaborate on that? Because for Europeans, the European Court of Human Rights, the German Constitutional Court, that's a bit of an odd way of thinking, not to pay attention to whether an error has been committed in the inferior court. And the second question relating to the process of choosing cases out of the 7,000 petitions is the rule of 4. Is it in practice really an important rule in the sense that in a lot of cases 4 justices decide on whether to take up a case, or is it more like a collegiate body that in a consensual process decides whether to take or not to take a case?
Let's see, which one should I start with, because I remember the second and the first question he asked me.
Why don't you begin with the second one?
All right. The second one is all of we confer every week or every 2 weeks, starting from the last week in September. Every petition received will be distributed to a law clerk pool to do a memorandum telling us what's going on in the petition. If ever I'm in doubt about a memo I get, I go back to the original papers and check myself. The chief then circulates a list of all the cases, say it's a 1-week interval and there are 300 cases on the list. He'll list all the cases that he thinks are worthy of discussion, not necessarily granting, but discussing. The rest of us then have 24 hours to add whatever cases we think we should discuss. So the moment the chief's list comes in, my law clerks then check my list to see if there's anything that he has not put on and ask me if I want to add it. So we will discuss only the cases that the chief or any of the other 8 of us put on the list. We discuss that at conference. We take votes. And if there are not 4 votes, the chief says denied. And if there are 4 votes, then it's a grant. What? Oh, error correction. Yes. I stressed that it's in large part luck that there are any particular 9 of us there at any particular time. We genuinely respect the views and think we are informed by decisions on hard questions made by other judges in the system. That's why we wait for what we call a deep split, so that we will have the benefit of the best thinking, and on hard questions often a division of opinion before we jump in and take the case. Now, it could be from a lowly matter like the paper bag case. We have in our Constitution a provision that precludes unreasonable searches and seizures. And there was a time when The police were stopping, say, an automobile because they had a tip about the driver. And the question was what they could seize and inspect without getting a warrant. And the court had drawn something like a luggage line. They couldn't inspect the suitcase in the car. But if it was a plastic bag, they could. And then all these cases came up with distinctions. How about a naugahyde bag? How about one of those thick... Well, I wrote a decision in the D.C. Circuit. I was then a Court of Appeals judge, saying... I remember bringing to conference every kind of container that we had in the house. And I said, are we going to have our police make judgments? So the D.C. Circuit came out with the rule, no, the police can take all those items into custody, but they have to go to a judge to get a warrant before they can open them. The Supreme Court said the D.C. Circuit was right that we don't want our police to make these distinctions so they can open everything. But the one thing that this array of decisions that drew this luggage line showed was that was simply unworkable. That line was unworkable. I wish I could think of... but we very often get excellent opinions on both sides. And the first thing that I look at is never the briefs that are filed by the parties, and not even the excellent bench memos from a law clerk, but I read the decisions on both sides of the issue that good judges in lower courts have written.
If I may add a brief question, you just mentioned that you wait for the deep split. You give opinions as a court in 1.4% of the cases put before you. What's the law for the other 98.6 cases?
Most of the law is made by the judge in the court of first instance because there's never any appeal. In a large number of those cases, it is a question of applying clear law to not so clear facts. So it really is a fact-finding exercise. The Court of Appeals, in many, many cases, they get it right. And if they get it right, there's no reason for us to intervene. If they get it wrong and another court says it's wrong, if it works, if they all agree that that's the law and there is no problem, there really is no need for us to intervene in most cases. So we try to settle what are the most divisive issues, like physician-assisted suicide, like the entrance of women into the Virginia Military Institute, like abortion. Think of the major controversies that the Supreme Court has settled because it had to. There was no one else in this system equipped to make the decision.
Are there any other... who's got the best one? Will you please speak clearly into the microphone?
I'll try. Early this morning, in gross violation of customary international law, juvenile offender Sean Sellers, who was only 16 years old when he committed 3 horrible murders, was executed by the state of Oklahoma. Last Tuesday, an open letter was sent to President Clinton, the leaders of the Senate, and to your boss, Chief Justice Rehnquist, urging that they take all possible steps.
Will you come to the question, please?
In one more sentence, thank you very much. All possible steps to stop the execution. My question to you is this. Having heard you speak this evening, am I correct to assume that there is nothing that Chief Justice Rehnquist could have done to stop the execution?
You have raised a question about an execution in the state of Oklahoma. I believe that case on the legal side, raised a simple question, and it raised a question about the exercise of clemency by the governor of that state. Clemency is a matter for the governor. It is a highly discretionary matter, and we don't have the authority to tell a governor he must or he must not exercise clemency, because that is a non-judicial authority. We live in a system of laws. That state gave that power to its governor. This man was not appealing that he didn't have a fair trial. He was not making any of the kinds of judicial claims that one might make, or he had at an earlier stage. But his petition, if I recall that case correctly, had only to do with the exercise of clemency, and that is a matter for the executive.
One last wonderful question.
Here. Yes.
Justice Ginsburg, my name is Adrienne Bothman, and I'm an American. I work here in Amsterdam.
Please speak into the microphone, otherwise the other people don't hear it.
Justice Ginsburg, my name is Adrienne Bothman. I'm an American. I work here in Amsterdam. And I wanted to ask you, I came to the Netherlands originally to study the International Criminal Court for the former Yugoslavia, and I wondered if you had any thoughts about the proposed ICC, the International Criminal Court. Thank you.
I can't speak in detail about the particular court. The idea of having such a court, I think, is grand, and sooner or later the world, I think, will come together on the realization that that kind of crime requires the support of all civilized countries in the world to apprehend and deal with. So I think it's a very, even though the United States didn't join that particular court, I think there's considerable sentiment that there should be such a tribunal.
All right, I think we're running late and propose that we call it an evening.
Well, as an economist, I feel somewhat of an outsider among this lineup of legal stars, but I'm fascinated nevertheless. Economists have only very recently come to realize the enormous importance of institutional infrastructure, legal infrastructure, quality of court systems, strength of enforcement mechanisms for economic performance, for the success of nations. We only now are starting to pay attention to it. You only have to look at places like Russia or parts of Africa and the enormous squandering of human talent that is taking place there to realize what happens when such institutions and such a legal infrastructure is sort of seriously deficient or even absent altogether. So I was intrigued by the discussion of Mr. Tjeenk Willink, who brought up the problems surrounding the emergence of European law, I think a European constitution, a European legal system. I suspect that the way we deal with those problems may well be very important for the long-term success of the European Union in ways that we still not fully understand, but are sort of clearly there. And I was fascinated by the review of the very clear, very insightful, the convincingly articulated review of the legal system in the United States and the important role of the Supreme Court in reviewing constitutionality. The system has clearly provided the United States with a stable infrastructure, with a very stable legal institutional infrastructure, legal infrastructure. But what I found fascinating is the way you described also the ability of the system to sort of move with broad economic trends, in the population at large. So it does provide stability that sort of the economy requires, but it also has the flexibility to sort of change when views in the society at large change. I find that fascinating. Well, it certainly inspired us, and I hope it will help us to deal with the problems that Mr. Tjeenk Willink brought up. Thank you very much, Justice Ginsburg. On a more practical matter, I also want to thank the audience for being here with us. You're all invited to join us at the Tetrode Library. It's somewhere hidden in the back. Some of you have been invited in person by the Economic Development Department of the City of Amsterdam. The others are welcome also, but you'll have to pay for your own drinks. The way you're going to do that, is by buying tickets at a desk that's set up for that purpose over there. And before I let you go, some housekeeping announcements. Our next lecture will be with the American novelist Dorothy Allison on February the 24th in the West India House. Allison's first book, The Bastard and Carolina, sort of an intriguing title, was a finalist for the National Book Award in 1992. Thank you very much. I hope we'll see you back again on that and on other occasions where John Adams Institute will bring great American men and women here. Just one final request. Could you remain seated until Justice Ginsburg and our guests have reached the library? Thank you.